Okay. Good morning. Let me start my video. Hang on. Hopefully the court can see me. Had some technical difficulty logging on this morning, so I'm using my iPhone. My name is Robert Kelly, Hillward and Henderson, counsel for the appellant. I'd like to reserve 3 minutes for rebuttal.
Very good.
Reversal is required in this case, Your Honors, because the trial court misapplied a condominium property tax assessment statute 718.120, with the result that it caused a double assessment to FT's property at the Five Towns development over in St. Petersburg. And more specifically, what got double assessed was the value of the rights held by the individual condominium unit owners in and to the property owned by FT. More specifically, those rights were direct easement rights for access and use of parts of the property, and secondarily, rights that were afforded the unit owners through something called a service and maintenance agreement to use certain recreational amenities consisting of clubhouse, tennis courts, pools, and so forth. To give it some perspective.
Isn't that something that would have to be raised by the individual unit owners, Mr. Kelly?
No, sir. The case that really controls this appeal, Your Honors, is the Morgan Woods Green Tree case, decided by the Florida Supreme Court back in the 70s. With one important, that case is factually and legally on all fours with this case, with one important distinction. The residential development in Morgan Woods was not a condominium, from what we can tell. And that's all important here, because here 718.120 prevents the separate assessment of condominium property. Like Morgan Woods, the only party in Morgan Woods was the developer, who's in effect the same posture as FT in this case. The unit owners in Morgan Woods were not parties to that case. The court there didn't concern itself with any kind of standing issue like the trial court did here below. What's astonishing about the final judgment in this case, Judge Black, is that the trial court never cited or discussed Morgan Woods in treating the plaintiff's claims for a double assessment. And
Mr. Kelly, Mr. Kelly,
ma'am,
didn't Morgan Woods ultimately conclude that it was proper for the separately owned property to be separately assessed and leaving the owner of the common elements to that situation free to collect to the unit from the unit owners by the assessment, which is essentially what you have here. The owner of the common elements gets to collect, they can collect those taxes through by the pass-through under the SMA.
Judge, the difference is the Supreme Court in Morgan Woods expressed, first of all, Morgan Woods involved, how do you treat easements in property for assessment purposes? And I submit to you that what the court talked about and what has been, and the rule that's been applied in many other cases is kind of a balancing test, like a seesaw type situation, where in this case, like in Morgan Woods, the properties that were benefited by the arrangement were the individual residential properties. They have an enhancement to their value based on the use rights they have over, we'll call it the developer's property, the common areas, we'll call it. By the same token, that property is burdened by the existence of those easements. And what
and wasn't the situation here, though, is that the burden is largely offset by the profit that Vesta and in turn FT realizes after they cover the expenses, right? We're talking hundreds of thousands of dollars a year.
No, well, there is a profit, Your Honor, and you're correct about that, but that flows not from the use of the easements by the unit owners or the use of the recreational amenities, but instead flows from and results from essentially the business that FT conducts by providing all the essential services to these 31 separate condominiums that comprise Five Towns, 1,700.
So they're being compensated for permitting the use.
No, they're not. What they're doing is they are charging back to the unit owners the costs, the direct costs of maintaining the recreational facilities, including the roads. But that's the same thing that happens in any condominium. If you own
But condominium associations are nonprofit. Here we have a for-profit organization distributing hundreds of thousands of dollars a year to its members.
Well, the analogy is to a management fee. Condominium associations commonly, and Mr. Dunbar testified to this, they commonly employ third-party managers to actually run the association, procure insurance, contract with a lawn maintenance company, a pool company, what have you. And those third-party operators make a profit.
So you're saying there's no management fee that is built into the actual costs that are being charged to the unit owners?
For for the services provided by FT, that's correct. Now, keep in mind the condominium associations still exist, and there are some things they still manage and administer on behalf of their unit owners. But and perhaps they employ third-party managers as well who make a management fee.
So I understand what you're saying, and I don't want to use up all your time on.
Well, let me get back to your question though about Morgan Woods, if I can, and that is that the court in Morgan Woods expressed a preference that if it could be done over again, they would have reduced the value of the individual lot owner's property by the value of their use rights in the recreational amenities, so that they could assess unencumbered fee simple to the developer, which is what happened in this case. Now, the only way,
but what Morgan Woods really said is the object of the game is to get to a just valuation for all the property that
correct.
is here, and here. Your argument is that the property shouldn't be separately assessed at all. It should be.
No, that's not my argument.
Okay.
This case is not about whether FT owns its property. It has legal title to the property, no doubt about it. And the value of the rights that it retains in the property should be assessed to it. We submitted a trial that the value of those rights are de minimis because the lion's share of the value of those rights are held by the unit owners and were assessed to the unit owners according to the testimony of the county's witnesses in the individual unit assessments. Now that was correct under 718-120 because those rights as easements and rights appurtenant intended to be used with the units themselves are condominium property by definition, 718-103-13. And under 718-120, condominium property cannot be separately assessed. So the county was eminently correct in including the value of those use rights in the assessment of the individual units. Where they went astray is by failing to recognize that they had already done that and counting those values twice in assessing FT's property. And this aligns perfectly with what the court said in Morgan Woods at page 759. They said, the record reflects that the assessor considered the effect of the easements and common areas in valuing the residential units, but did not adjust his valuation accordingly on the servient common areas. That would be FT's property. To this extent, the assessor's exercise of his authority was invalid. We affirm the action of the trial judge and direct that the subject properties be reassessed in accordance with the views expressed in this opinion. And that's why we're asking for a reversal and a remand with instructions for the property appraiser to reassess FT's property by deducting the value of the rights held by the unit owners and leave only to FT the value of its retained rights.
That wasn't the position that your client took at trial, was it?
Pardon me, sir?
Was it your client's position at trial that it owed no amount of taxes, it was not liable to pay anything because the property was encumbered by these easements?
Well, its position was.
That's not what Morganswood stands for.
No, well, I beg to differ. Your Honor, the position at trial was that the value, if any, to FT was de minimis. There was no evidence presented on a dollar figure on what that value was, which is a reason why we need to remand with instructions for a new assessment to be made by the property appraiser consistent with 194.301.
So what did your client establish at trial as far as its responsibility for any of the taxes on the property?
Well, what the client established at trial, and this is through the testimony of its expert, Joni Herndon, at page 284, was that first of all, let me back up a step. First of all, Mr. Hayes at page 369 to 370, answering the trial court's questions, stated unequivocally that the county included the value of the owner's use rights in the individual unit assessments and made no downward.
Which goes to the question that was posed earlier, that may have been an over-assessment to the unit owners, correct?
No, it's not. It's not an overassessment. It's part of the balancing test. So the unit owners own those rights, those sticks in the bundle of rights. They own those, and they pass them along when they sell their unit, and their unit should be valued based on the value of those rights, because those rights are condominium property and they can't be separately.
Would that value be impacted by the cost to the unit owners, the obligation that they are liable for under the contractual documents?
No different, Your Honor, than any other type of condominium. There's no free lunch, Your Honor. And in any condominium, the unit owners are charged back through their monthly fees the cost of maintaining the swimming pool, maintaining a tennis court if there is one, maintaining common areas like meeting rooms and so forth.
So would the reduction in value for your client based on the easement rights be offset in any manner by its receipt of income for use of its property?
I don't quite follow your question, but in this situation, if there is a reduction in FT's assessment, which there should be, the refund that results from that would be a surplus under the service and maintenance agreement and would be subject to repayment back to the residents.
Your position at trial was that the entire taxable value was paid for by the unit owners and should not have been attributed to your client.
That's correct. That the unit owners were passed through the actual taxes that FT paid. So in fact, the unit owners paid twice, but the property was assessed to FT as it should have been. And the remedy here, the remedy here, consistent with Morgan Woods, needs to be a remand, like the Supreme Court dictated. Remand.
But what you're arguing now is not what was argued in the trial court. The argument,
no, yes, it is.
The argument in the trial court was that FT should have no liability for taxes because it was all passed through or should have been passed through to the unit owners.
Well, no, Your Honor, I beg to differ. What the position of FT at trial is that the assessment of its property should be a de minimis or nominal number, because the line, 99.9% of the benefit or the use rights of this property, these roadways, the ponds, the swimming pools, et cetera, are enjoyed by the unit owners, and they pay for that when they buy their units. And that was.
I have a question. I have a question for you.
If the case went back, would it then be? Go ahead, Judge. Go ahead. You were in first.
And this is a different angle. I'm sort of in alignment with Judge Silverman about we're hearing a little bit of a different case on appeal than what I read happened at trial. To me, and correct me if I'm wrong, a big part of your argument was that the Chapter 718 and the tax statute that have essentially parallel text that permit the appraiser to assess this common area property against the unit owners only if it is owned by the association or jointly by the unit owners. I read a lot about how those statutes should be interpreted and how that affected your client's position here. And we're not hearing about that at all now. And it seems like—
no. Then that's my fault, because I think absolutely that needs to happen. In other words, there needs to be an entry on the tax roll for these 11 parcels to be assessed in the name of FT. But the question here is, what value should be ascribed to that separate assessment? And under the Morgan Woods balancing test, which is now mandated because this is under 718-120, because this is a condominium, the value under FT's name should be nominal, $100 or so, which is a number property appraisers use. They never put zero on something, but it's a nominal number like $100. And the rest of the value eliminated because it was already, admittedly by Mr. Hayes, included in the assessment of the unit owners, the 1,700 units. They got assessed the value of the roads, the green space, the ponds, the pools, the tennis courts, the clubhouse. And so by assessing it again separately to FT, the property appraiser double assessed the value of those use rights.
Was the value of the use rights alone quantified on an individual unit basis, or is that something that would have to be done if we were to agree with you and remand this?
That would have to be done on remand, Your Honor, and
They'd have to go condo by condo and figure out what the value of this is, and then you would be entitled to a reduction. Is that what you're?
No, sir. What would happen? What would be required on remand is what Ms. Herndon explained at page 284 of the record of the transcript, and that is you need to look at the assessment of FT, and it was something like 2.4 million in the aggregate, and figure out what part of that 2.4 million reflects the value of the rights held by the unit owners, and subtract that after you quantify it, subtract it from that 2.4 million assessment, leaving what's left to FT to pay.
What about the part of the record that showed that the assessor had assigned some value for at least some of these amenities and only had put one multiplier on it, so that the argument, if I understood correctly, was that that's already been done?
No, I'm glad you bring that up, and that was a source of much confusion below. But here's bottom line: the multiplier of one is like a factor of one, and so if you have a condominium in 5 towns that's being assessed that has the rights to use a pool, tennis, and clubhouse, as the appendix exhibits show to the brief, the Ys that are there, and you are assessing, you're going to assess those units using only sales from other units in 5 towns that also have those rights. There's a multiplier of 1 applied from the sale properties to the assessed properties because they all have the same rights and amenities. In other words, there's no need for an adjustment, Your Honor, between the comparable sale and the property that you're assessing. And what Mr. Hayes was confused about at trial is he was asked a couple of times, was any part of the physical real estate owned by 5 towns included in the unit assessments? And he said no. And that's probably true. But what he didn't realize is it's not the physical real estate, it's the use, it's the rights of use. It's the sticks in the bundle of rights from FT's fee simple title that was included in the assessment of the units. And he said that unequivocally in response to the trial court's question at pages 369 and 370. And the trial court actually heard that. You know, it's like the drop touchdown pass in the end zone. She had the ball in her hands. She recognized on page 370 there was a double assessment occurring, and somehow between that moment and the final judgment, the ball slipped away. And you know, and the only way that, frankly, the only way the judgment could have been written the way it was is to ignore the Morgan Woods case, which is what happened, not discuss it, because the Morgan Woods case is on all fours, except that didn't involve a condominium. And so because this is a condominium, and because the easement rights and the use rights over the recreational amenities are condominium property, they must be assessed to the unit owners. That is the rightful place to put that value. It cannot be separately assessed to FT.
Just to let you know, Mr. Kelly, you're at the 3-minute mark if you wish to reserve the rest of your time for rebuttal.
I do. Thank you, Your Honor.
Very good. Ms. Vicari?
Good morning, Your Honors. Kelly Vicari on behalf of Appali, Mike Twitty, Pinellas County Property Appraiser, successor to Pam Duveau. Your Honors, in this case, the appellant has relied on a selective and inaccurate interpretation of the Condominium Act, which the language thereof is unambiguous. An application of the facts of the case to the unambiguous statute leads to a conclusion that the property appraiser correctly assessed the subject property at full market value to FT, and that the unit owners at 5 towns were not improperly taxed or double taxed. Those are the 2 issues on appeal. As Your Honors pointed out, this argument now pertaining to the easement is something new that appears to have been really brought up for the first time within the appellant's reply brief. The issue was not preserved for appeal and was waived by the appellants. There was testimony in the lower court by the appraiser for the Pinellas County that he considered the fact that there is an easement and access rights of the unit owners when performing the assessment of the subject property. But the methodology and the valuation or the weight of consideration given to those easements was not contested at trial. Regardless, though, that testimony is sufficient to comply with the property appraiser's requirements under the law. I do want to touch on the Morgan Woods case. The Morgan Woods case is distinguishable from our current situation. The first thing I want to point out is that in Morgan Woods, you had unit owners and you had a condominium association. Pursuant to the declaration, there were easement rights And within those easement rights included easements for recreation, ingress, egress, lateral support, and parking, etc. That is not what we have in this case. There is an easement for ingress and egress of the roadways. And then separately, there is a service and maintenance agreement that is attached to the declaration. Those are two very different things. So the easement of the ingress and egress was considered properly, which is all that's required by Morgan Woods. Morgan Woods simply says that an encumbrance must be given consideration, but it does not per se reduce assessment value. The service and maintenance agreements themselves are contractual.
It does go on and say, this does not mean, however, that an assessment may be made without regard to the effect of an encumbrance on the value of land. And I think Mr. Kelly's position as well, the value of this encumbrance was so great that it essentially wiped out any responsibility for taxes on the part of his client, which seems to be stretching Morgan Wood a bit beyond what it says.
Yes, Your Honor, and I do agree that the case does provide that you have to take into consideration the easement, which again, the property appraiser testified that he did. But again, I want to point out that the service and maintenance agreement itself, that is not an easement. And the property is not burdened by that service and maintenance agreement.
Well, for the moment, let's stick to the evaluation relating to the easement itself, because Morgan's Wood does say that whatever value is attributable to the easement does impact the owner's valuation. So how did the easement get taken into account by the property appraiser?
Well, the testimony at trial was that the property appraiser did consider the easement. From the property appraiser's perspective, the FT is not burdened by that easement. If anything, it's benefited by the fact that the unit owners have the easement for ingress and egress, and then also they obviously have the estimate.
How is that a benefit to the property owner?
Well, it's only a benefit to the property owner if you take into consideration additionally the service and maintenance.
Well, but you're trying to separate the two.
I am, Your Honor, and I apologize. So they are separated. So really
if Morgan's Wood says the encumbrance, that an assessment may be made, let me start over. This does not mean that an assessment may be made without regard to the effect of an encumbrance. The encumbrance is one factor among many the assessor must consider. So what did the assessor here testify to as how that encumbrance was taken into account?
Well, Your Honor, I believe that the testimony was just that it was taken into account. I don't believe that there was cross-examination or contesting whether the easement was taken into consideration properly, the weight or methodology of that. That was not an issue that presented during the testimony. The focus of the trial was really on the appellant's argument that it should not be taxed at all for the subject property pursuant to the Condominium Act. If I
recall correctly, the witnesses for FT basically went along those lines. Am I recalling correctly that there was no testimony offered by FT that in fact 100% of the valuation, the number that the property appraiser came up with, was a full valuation without any consideration of the easement rights?
I'm sorry, Your Honor, could you restate? I don't think I caught it.
I'm not sure I got that question either. The valuation testimony that was offered by the property appraiser was, we took into account the easement rights. Was there any contrary testimony offered or any evidence to the contrary of that in fact, the property was valued at 100% ownership value without any reduction for the easement?
No, Your Honor, the argument at trial really commingled the easement and the service and maintenance agreement issue. So the argument was that they shouldn't have been taxed because there is this benefit under the service and maintenance agreement, but it was not pertained to the actual easement itself, which is merely an easement for ingress and egress of the property. And there's not, just because there's
am I understanding your position basically that the easement rights had to have been taken into account under Morgan's Wood, and the property appraiser's testimony was that it was taken into account, but nobody testified as to that valuation, how it impacted the assessment?
Yes, Your Honor, that's my understanding. There was no challenge, though, made by appellants as to the fact that the appraiser said he considered it, and all that's required under Morgan Woods is the consideration. It says that it won't per se reduce. And the property appraiser also cited to the case of Hillsborough County versus Cordham. It's a Florida 2nd DCA case from 1991, which actually cites to Morgan Woods in support of its conclusion. In that case, the court held that when there's a right-of-way easement that encumbers a property, the owners of the realty are still responsible for the taxes. And in that case, the challenging party failed to present any evidence that the easement was not considered properly within the property appraiser's valuation. And it must be presumed that the property appraiser followed the statutes and rules and considered all relevant factors. So again, in this case, we had the property appraiser who testified that in performing the assessment of FT's property, he used the cost approach, which looks at the value of the land plus the improvements thereon. That the easement, which is really only for ingress and egress, was taken into consideration. And he assumed when doing the appraisal that the unit owners had access rights. But again, the appraisal was done using the cost approach. I'll now turn back to the first issue on appeal, which was the interpretation of Florida Statute 718.120, which provides that taxes may not be separately assessed against recreational facilities or common elements if the facilities are owned by the condominium association or are owned jointly by the owners of the condominium parcel. In order to interpret this statute, we have to look at the definitions. Common elements is defined as the portions of condominium property not included in the units. So the main definition here, the crux of this case, fell on the definition of condominium property. And that definition states that the lands, leaseholds, and personal property that are subjected to condominium ownership, whether or not contiguous, and all improvements thereon, and all easements and rights appurtenant thereto, intended for use in connection with the condominium. So pursuant to the plain and ordinary meaning of this statute, condominium property must be owned by the condominium. In this case, we know that FT owns the subject property in fee simple. The unit owners merely have a non-exclusive contractual right to use but not to own the property. They take no part in the decision-making process as to what rules or regulations will be over the property. Their right, again, is non-exclusive. There was testimony at trial that currently the unit owners are the only ones using the amenities in the property, but there's nothing that would stop FT as the sole owner from opening up those amenities to the general public. Appellant had argued that the subject property was an appurtenance, even though it's not owned by the condominiums, which again is in direct conflict with the statute. They've cited to 718.106, again, that discusses appurtenance and states that with an appurtenance or with a unit, an undivided share in common elements and common surplus will pass as an appurtenance, and other appurtenances may be provided in the declaration. Again, in this case, we have a service and maintenance agreement attached to a declaration. There's nothing within the condominium declaration that discusses the subject property itself as an appurtenance. So accordingly, the property was appropriately taxed at full market value to FT as the fee simple owner. As to the second issue on appeal, FT did fail to prove that the unit owners were improperly assessed for the subject property. There was discussion previously about the fact that the appraiser marked yes for amenities, which is really just an identifier saying that there is a pool, there is a clubhouse. However, a multiplier of 1 was used, which means that there was no value added to the assessment for the subject property. Additionally, only units within 5 towns were used as comparators with each other. There's 1,700 units within 5 towns. So there was ample sales comparison information available to the appraiser. This is such a unique situation where the developer of 5 towns has retained ownership of the subject property, of the green spaces, the amenities, the roadways. There's no other property like this within Pinellas County. So the most accurate way that the property appraiser could move forward was to assess those unit owners only against each other because of how unique this is. The value of the subject property is not inherent in the assessed value. There was testimony at trial that the unit owners know that they can use the amenities on the subject property for a fee, but they know that they do not own the subject property. Accordingly, there was insufficient evidence presented by appellants that the property was assessed or taxed twice. And even if it was, FT is not the aggrieved party, rather it would be the unit owners. The unit owners were not parties to the litigation, nor were any of the condominium associations. So FT does not have standing to bring a claim on its behalf. Any refund due to the unit owners, if awarded to 5 towns, would be a windfall to the appellants.
Counsel, before you go on, I was trying to find the testimony presented on behalf of your client, going back to this easement issue. It appears that I'm not finding, and I'd like you to point me to where the testimony is that the full value was adjusted downward because of the value of the easements.
There is, Your Honor, I'm sorry, there is no testimony that the value was adjusted downward based on the easement.
You said earlier that the property appraiser said that it in fact was taken into account.
Taken into consideration, yes, but there was no testimony that there was a downward departure in the appraisal, just like the Morgan Woods case states.
So how is it taken into account if there's some dollar value attributable to the easement and the property appraiser testifies that FT's assessment was the full taxable value? How does that support your argument that in fact the easements were taken into account? And I'll give you an example. If the full taxable value is $1 million and the value of an easement is $10,000, then wouldn't the ultimate bill to FT have been $990,000 rather than $1 million?
I understand the question, Your Honor, and I think that the issue in this case is because the complaint and the trial really were not an assessment challenge, that the testimony from the appraiser was more conclusory.
You said a few minutes ago that the easement value was taken into account.
Right. Yes.
So how is it taken into account when it would be a reduction in the taxable value to the owner?
Your Honor, my position is just that the appraiser testified conclusory testimony that the easement was taken into consideration. There wasn't an expansion on that at the trial to go into the methodology or the calculation.
Didn't your witness also testify that the full taxable value, the full value, was charged to FT and that there was no adjustment, or there's nothing in his testimony indicating that there was an adjustment for the value of the easement? So help me understand that. You can't have him testify that the full amount was taxed because there was no other valuation to reduce it and say, well, it was taken into account. So help me understand that.
Okay, well, Your Honor, I believe that the testimony is that FT was taxed at full market value. However, to get to that full market value, the appraiser took into consideration the fact that there was an easement for ingress and egress, which will not per se reduce the value of the assessment. So the appraiser used his judgment to determine the impact of various elements on the property and took that into consideration. Unfortunately, there wasn't testimony that went further than that because his testimony was accepted by the parties. It wasn't challenged as to, how much did you allocate for the easement? What would it have been otherwise? We just didn't get to that. It was a conclusory statement by the appraiser that yes, he took that into account when coming to full market value for the property.
So this is one of those questions, to go back to something Judge Black said in the earlier case. This is somewhat of a softball question because what Morgan's Wood says is that it is a factor among many. You haven't really made that argument. And so is that now your argument that the property appraiser considered it, but it didn't impact the valuation because of some reason that's unstated on the record?
Right, Your Honor. I'm sorry that if that was not clear through the argument. Yes, because that is what the case stands for. It is just to be considered. It's a factor to be considered. And it does not per se reduce the assessment value of the property.
How can it not reduce the value to some extent? I mean, if you own property and you can do whatever you want with it and nobody has any rights to it, it seems pretty obvious that that's of greater value than a property where others have access to it by some easement for, there's restrictions on the use, or at least if you're going to convince me that it doesn't make any difference, there should be some attempt at making that argument. In other words, if an identical parcel is taxed at full value, full value would seem to be more than a parcel that has limitations on its usage.
Yes, Your Honor, I think at trial, the testimony was just that it was considered in making the assessment.
Because my understanding is that that property, and I believe it does have value that's taxable. It generates a stream of income. It is a fee simple ownership, but there are restrictions on what that property can be used for. Like, for example, there's a couple swimming pools on the property, right? There's tennis courts, there's all sorts of things. And those need to, those under the encumbrances on that property, those can't be removed.
Well, Your Honor, our position is that the pools and the amenities on the property, the benefit of the use of those by the unit owners is captured within the fee that they pay under the service and maintenance agreement. Those themselves are not easements that would burden the subject property or reduce the value. That's why I was trying to kind of separate out earlier the fact that we do have an easement for egress and egress that only goes over the roadways, which is separate and apart from this contractual use to use the amenities of the property.
So are you saying that particular burden carries no value one way or the other?
Yeah, I actually, the position is that it's not a burden. They can use the subject property in whatever manner they would like. There's a contract that they have. They receive a fee in allowing unit owners to use their property, but the unit owners have no say really in anything, how it's used, who manages the property, where their fees go to. You know, at the end of the year in 2015, the subject property received a surplus of over $359,000 from the service and maintenance agreements.
Right.
So that's not a burden on the property. If anything, that enhances the value of the subject property. But more importantly, the appraiser did use a cost approach, which is just looking at the value of the land and the improvements thereon. The appraiser did not do an income approach in this property. The valuation would have been much different. So using the cost approach, they just looked at the value of the property, the improvements thereon. And yes, there's an easement for roadway. But again, case law says that that does not per se reduce. We know only from the testimony that the appraiser said he considered it. To what degree, we don't know, because that was not brought up at trial. And so our position is also that that's really not preserved for appeal.
Okay, thank you.
You have about 30 seconds left if you wish to wrap up.
Your Honors, I think that really the crux of this case came down to the statutory interpretation of 718, and it's clear from a plain and ordinary meaning that to be considered condominium property, the property must be owned by the condominium. In this case, the property is not owned by the condominium, but rather FT, a company. To be considered condominium property, FT would have to transfer ownership of it to the condominium associations, and therefore they would be taxed. However, unless and until that happens, the property is appropriately taxed against FT.
Very good. Thank you very much, Mr. Kelly. Before you start into your presentation, I do want to ask a question about the testimony at trial. I said this earlier, and I'm still troubled by the fact it appears your client pursued basically an all or nothing strategy. You've got the property appraiser's testimony, you have Mr. Dunbar and other witnesses' testimony. So what dollar value did your client as the plaintiff establish was the amount of overtaxation based on the assessment, the easement having some reduction that should have been attributed to benefit your client?
So, Your Honor, there was no direct testimony by Ms. Herndon or anyone else on behalf of the plaintiff of a dollar amount. However, there was ample evidence that the assessment was invalid because of the violations of law and Morgan Woods. And under 194.301,
there is testimony.
Statute says
there's testimony by the property appraiser that basically the correct amounts were taxed to FT, that whatever, I don't remember the exact testimony, but that everything was taken into account. I don't recall there being testimony as to specific adjustments. So we're at trial. Does your client have any burden to show that the assessment was wrong because X number of dollars was incorrectly attributed to your client's bill?
Well, what Yes, the plaintiff does. And let me explain how they satisfied that burden. They put on evidence, first of all, that the subject property was assessed at 100% value to FT. That position has been consistent by the property appraiser throughout this case. Second, they put on testimony that the value of the unit owner's rights through the easements and the use of the recreational amenities was included in the assessment of their units. At page 369, Mr. Hayes answers in response to Judge Allen's question. She says, was there ever an effort made to back out the value of the unit owner's property, the use of those amenities? He said no.
And under Morganswood, the Supreme Court has said, there are a lot of factors that come into play for an evaluation. Easements and burdens are one factor to be considered. So I'm going back to what I asked you earlier. How did your client establish that X number of dollars was improperly attributed? And I think what I'm hearing you say is it was all wrongfully attributed to your client because it all should have been taxed and was taxed to the unit owners.
What I'll tell you, Your Honor, is there wasn't a witness who said the proper assessment for FT should be zero. There was ample evidence that the value of these use rights were included in the assessment of the 1,701 condominium units. And on that basis, under 194-301, the statute says if the record lacks competent substantial evidence as to what a proper assessment should be, the court should remand it to the property appraiser to calculate that assessment. That's the relief we're seeking in this appeal. And, go back to your question, your observation about Morganwoods, that an easement is but one factor that may be considered. The property appraiser was aware of the easements and the use rights and the recreational amenities, and he thought about it, but that's about as far as he went. He made no adjustment to FT's assessment to offset the value of the rights that he assessed to the unit owners. And under Morganwoods, the court simply said this: when you have a burdened property and a benefited property, you can do two things. You can either ignore the benefit to the dominant estate and ignore the burden on the Serbian estate, or conversely, you can recognize the benefit to the dominant estate, which is what the property appraiser did here. But if you do that, then you have to recognize the burden on the Serbian estate. If I have a house on Kennedy Boulevard with a pool in the back and I have direct access to Kennedy, and Judge Black lives behind me with no direct access, and I give him the right to cross my property to get to Kennedy, and I give him the right to swim in my pool if he shares in the expense of upkeeping it, that's the situation we have here. If the property appraiser in assessing Judge Black's house includes the value of those rights in his assessments, then under Morganwoods, they have to recognize the burden of the rights on my assessment. That's not what happened here.
I've let you go on a little bit, unless Judge Black or Judge LaBritte has a question. Then you'll need to wrap up in about 30 seconds.
Yes, sir. We rely on the briefs for some of the points, like the general public can use the property, or there's a fee charge for the use. That was never established below. We simply are asking this court to reverse on the authority of Morganwoods and remand with instructions to the property appraiser to reassess FT's property by quantifying the value of the unit owner's rights and deduct that from the assessments. Thank you very much.
Very good. Thank you both.
Thank you.
The next case is Cortelli versus Howell Cortelli. And for those who are waiting for